Skepiso Makwetla.
Right, let's take a look at an important ConCourt decision that was handed down. And it was a unanimous ruling that the Constitutional Court of South Africa has declared key provisions of the Refugees Act unconstitutional. On Tuesday, the Apex Court handed down a judgment that struck down the 2019 amendments to the country's Refugees Act, which allowed officials to reject asylum claims on procedural technicalities. Now, the court concluded that the act violated the international legal principle of non-refoulement, which prohibits governments from sending people back to countries where they face persecution or danger. And the ruling confirms a judgment that was made by a lower court a year ago. Civil rights organization Helen Suzman Foundation has welcomed the judgment. Let's speak now to Helen van der Linde, who's a senior researcher at the Helen Suzman Foundation. Helen, thanks very much indeed for joining us, and warm welcome to the program.
Thank you so much for having me. Excited to be here.
So help us non-legal people, in simple terms, what did the Constitutional Court actually decide yesterday, and why do you feel it's a really important judgment?
Right, so the Constitutional Court declared these provisions unconstitutional. That is to say that these provisions don't comply with our Constitution, upholding things such as the right to dignity. It looked at the reasons why these different hurdles were put in place around asylum seekers having to prove how they entered the country and having to prove it before they even make an application, as well as after they make an application. So this means that it put in provisions where a person has to prove numerous times how they entered the country and whether or not it complied with the act itself. Why this is quite important to be struck down is that it looks at the fact that people weren't able to even make applications in the first place. So the merits of their case were never even considered. This is also important for children of asylum seekers, as many children have to bear the consequences of their parents' decisions, and they have no control over how they entered the country or when they entered the country.
Yeah, I mean, often when laws are created, they're trying to solve a problem. What problem was the South African Parliament trying to fix when they came up with these 2019 amendments? And were they justified in their concerns? And I guess if that's the case, was there another way to solve it rather than the way that they did?
Yes, so what we can think Parliament was trying to solve is that there's an incredible backlog at the moment in the Department of Home Affairs looking at asylum seeker applications. And because each case needs to have someone really considering the facts and looking at things such as the country situation, this is quite a time-consuming activity, which has created tremendous backlogs in our asylum seeker process. So the government was trying to place a hurdle so that sort of administratively, this would be able to exclude people quicker so that people could leave the country quicker. However, they're not dealing with the roots of the reasons why this backlog exists in the first place. And those are things such as the refugee status determination officers do not have up-to-date information about country situations. They're not necessarily trained in how to assess these different reasons why someone enters the country. Often it's left up to their own discretion, which makes the application of the different reasons why quite inconsistent. What they need to actually address is the underlying reasons for the backlog. They need to assist with training RSDOs, the refugee status determination officers. They need to get more of them, and they need to definitely improve how they store files at the Department of Home Affairs.
So I guess for someone who's seeking asylum today, what practical difference will this judgment make? And I suppose the law, the way it works, it's not retrospective. So somebody between 2019 and now can't now go to the court and say, this is what you did wrong in between. Please review my case, or can they?
Right. So what this will have the consequence of now is that when someone comes into South Africa as an asylum seeker and they aren't able to get an asylum seeker transit visa, they will not have to first prove how they entered the country and why it is that they don't need, why it is that they never acquired this permit in the first place, which is fortunate for them. It's less administrative hurdles. I think going forward, the asylum seekers would need to approach various NGOs in order for their rights to be upheld and to bring it before a court, which unfortunately now does also create further backlogs in our judicial system because there's a need for a judicial review.
So there was a word I used a little bit earlier on, the principle of non-refoulement. I'm wondering if I'm pronouncing that correctly. What is that?
Right. So the principle of non-refoulement is that a country may not return a person to another country, their country of origin, if that is going to result in the persecution of that person or that they will come to serious harm. So, of course, then when people are denied asylum seeker status or even refugee status based on a procedural hurdle, this can potentially contravene the principle of non-refoulement as they're sent back to that country where they are going to face persecution.
I suppose this is where the big challenge is for a system like this, because some countries will create the impression that they're fully democratic and there are no problems in that country in terms of how its citizens are treated. For example, Zimbabwe. It is very difficult now in 2026 to say that there are instances where you may face persecution, etc., etc. But the Zimbabweans will tell you, yes, I do. What does a country like South Africa do in an instance like that if someone comes in and says, I'm seeking asylum from Zimbabwe?
Well, that is where the refugee status determination officers are meant to have up-to-date country assessments and situations. At the moment, South Africa has a very out-of-date document on this, allegedly, and the country then needs to undertake a factual look at Zimbabwe and what is actually going on the ground. It is very common in the news that people do report on these various instances of persecution as well as economic difficulties. So really, the Department of Home Affairs just needs to undertake even a desktop study just to see the up-to-date information as well as any unfolding situations such as in Tanzania and in Kenya, so that there can be up-to-date situations in front of these RSDOs so that they can make informed decisions when they are assessing people's cases.
You also said that what it means is that the person doesn't have to say how they got into the country, etc. My understanding, again, I'm a layperson, is that if you're in Tanzania and you feel that you are unsafe, the idea is that you must go to the nearest country to you that is safe, which might be Rwanda or Kenya. Is it then not a problem if someone crosses 3 or 4 borders to end up in South Africa and say, I want to be in a safe place, and I've skipped all these other countries that should have been my first destination? And hence, they ask the question, where have you come from? How did you get here?
Yes, so this is often referred to as the first safe country principle, where they look at what is the first safest country in proximity to your country. So, for example, with Tanzania, as you said, people could perhaps cross over into Kenya, into Rwanda. Perhaps if they even go around, it might be Namibia or Botswana. So those definitely are contributing circumstances to considering an asylum seeker application. However, one also needs to look at the situation in that country. So, for example, if someone were to cross down through Mozambique, one would need to look at what is the situation in northern Mozambique, in Cabo Delgado. When people enter the country and they look at how they entered the country, it is Mostly around whether or not they entered through an official port of entry. So many asylum seekers do cross over into South Africa outside of an official port of entry. And that is perhaps through the Limpopo River, or they're smuggled through in a bus, which could be that they're victims of human trafficking, or perhaps they didn't receive an asylum seeker transit visa at a port of entry, which might not be their fault, as the DHA has been known to either reject or just refuse to issue an asylum seeker transit visa, which is detailed in Scalabrini's argument.
So the other thing that I know for sure, because I have people who work closely with this kind of thing, that there are people who are purposefully abusing South Africa's challenges. As you say, capacity is an issue. And then once you start a legal process, all bets are off for sometimes an indefinite period because the system is just so clogged up. How does South Africa protect itself from abusers then?
Right. So these are also considerations the government must take in terms of if they have up-to-date country profiles, they're able to make these decisions coming from a factual place, so that they can actually see whether or not there are people who are trying to abuse the asylum seeker system. And whilst I do have a lot of sympathy for a lot of people working in the DHA, I believe many of them are just trying to do their jobs and make sure South Africa is a good place to live. They need to also make these decisions based on the merits of the case. And all people are entitled to accurate and fair procedures. So whether or not they are an abuser, they need to just be able to access the asylum seeker system in the first place. And from then on, the RSDO should be able to make a decision based on the merits of it.
So bottom line, what I'm hearing from you is that there's not a problem with the legislation. The issue is the administration that needs to be dealt with.
Most definitely. The DHA definitely needs to improve their capacity. That is a very, very large problem, which leaks over into our justice system, unfortunately, with court backlogs on these matters.
All right. So I guess the cases that have been work in progress now revert back to pre-2019. Is that what this means in terms of a judgment?
Well, it might not have a retrospective effect, but I would say that asylum seekers would need to actually approach different NGOs in order to hear the merits of their case and if they're able to be assisted. Yeah.
Do citizens get a say? Because we're seeing at the moment a lot of issues coming through, particularly with undocumented migrants, and there seems to be a sentiment in the country. Do citizens get a say in terms of we actually don't want this international standard. We want our own standard for our own country to deal with refugees?
So in terms of court processes, citizens do not get a say. However, citizens are always able to write to Parliament with their various ideas, with their sentiments, and at the Department of Home Affairs, there will be people who read these various letters, for example. However, there is an immigration bill that is currently pending before Parliament. It unfortunately closed to comments earlier this year, and the first safe country principle is contained in that immigration bill. So if that bill is adopted as is, it's a white paper that will become a bill. At the bill stage, there'll be another round of public consultation and people can comment. Then when it is eventually adopted by Parliament, possibly, then this aspect will be implemented. So if I have to say the white paper rather is closed, however, when it does become a bill, then citizens will have a say in order to contribute, but then the Parliament will adopt it how they deem is important to adopt it in whichever form.
Okay, so the 2019 amendments you were concerned about, and this has now been dealt with. Are there any other areas, reforms that government perhaps has put on the table, planning, that worry you?
Well, The white paper on immigration is a little bit of a difficult paper and is quite concerning. It does not detail a lot of information on how certain principles are going to be adopted or how certain reforms are going to be rolled out. There's also the instance where they refer vaguely to regulations. However, these regulations have not come alongside the white paper. And what we found in the past is that in certain instances, it's taken up to a decade for the government to promulgate these regulations. So where these documents are not being put forward on the table alongside the bill, it's concerning to think about how long is it actually going to take for the government to put out these regulations. The first safe country principle can be worrying as well in certain cases of persecution where they might say, oh, but this country is a safe country. For example, if someone's fleeing violence in Uganda as an LGBT person, they might say, oh, but Botswana is the first safe country. However, whilst there aren't necessarily extreme criminalization laws, there's still sentiments of anti-LGBT attitudes in the country that can expose people to violence. So this is where the principle becomes a bit tricky as well, and it is contained in the white paper. But I would say that the main concern is around how the government plans to roll out their proposals in the white paper and how long is this actually going to take.
Okay, so in the end, you're delighted with the Constitutional Court's ruling, and it's a significant judgment in your view.
Yes, it is a significant judgment. I believe then that people will actually have their cases assessed on the merits of the case and not the procedural hurdle, and they won't have to constantly revise how it is that they got into the country. It's also a positive for the children of asylum seekers, as they will not have to bear the consequences of their parents' failures to report to the refugee reception officers or to justify how they got into the country.
I know this is completely off topic now, but you did mention children, and I am curious about one thing. I know that the law changed as well about children taking the status of their parents at the time that they were born. Is that internationally acceptable? Because if you're born in a country, in theory, you become a citizen of that country, no matter how your parents got there. Your thoughts on that quickly? I know I've taken you off topic a little bit.
No problem at all. Yes, this is an accepted principle in international law, and many countries do also have that principle in their law. It is called citizenship by birth. So it is where if a child is born in a certain country, you acquire citizenship automatically upon birth. But South Africa does have additional requirements around that, which is that the child must have lived in South Africa the entire time until they were 18 years old. So it is not just automatically acquired by birth. There are some additional requirements on that.
Chanel, thanks very much indeed for some insightful commentary on this, because I think it's a kind of thing that people probably don't pay enough attention to and then may react emotionally. But thank you so much indeed for your thoughts and explanations of why this ConCourt ruling is something that we should be paying attention to. Thanks for your time.
Great. Thank you so much.
That was Chanel van der Linde, who's a senior researcher at the Helen Suzman Foundation, speaking to us about this Constitutional Court ruling that said that 2019 amendments to the country's Refugee Act were unconstitutional, and they've been reversed. So if you're a refugee coming into the country, you no longer have to explain how you got into the country, where you came from in the first instance. The government must take you in and follow due procedure. It's 7:30, which means it's time for your news headlines with Jwalani Tulongwepe.